Hello and welcome. Today we're going to talk a little bit about the patent process. In fact, we're going to go over the details of what you need to do as an inventor if you want to go and file your own non-provisional patent application. The process has several parts to it. What I'm going to cover today is I'm going to show you the US Patent and Trademark Office website. And then from there, I'm going to try to explain to you the various steps. And then at the end, we'll do some questions and answers. So let's just get started right away. I'm now going to share my screen that will show specifically the US patent website. Let me go back to the beginning. So when you go to the uspto.gov, you can enter any kind of term that you want to search for on the website. I entered inventor assistance. So the word inventor assistance is put into the search box and I tell it to go and do a search. It will bring up a whole list of things. What you're looking for is the Inventor Assistance Center. This is something that the USPTO offers. There's no charge to using this service, so you can simply just go in and click on it, and it will take you to a whole list of things that you can do. Here is the Inventor Assistance Center. What is the Inventor Assistance Center and what can it do for you? Here's an explanation. The most important part is all the resources they have here. These are the 4 steps that we're going to cover today. What do you need to do prior to filing your application? So here's all the different links that you can check on. What you need to do during the examination process. What happens if your case is allowed or if your case is abandoned? And then there are various things that you can look for in terms of the forms that they have, all the different applications and forms that are available to people. So as an inventor, if you're going in to file your own application, there are basically 4 things you need to do. One is you need to gather your thoughts on your idea and prepare your patent application. The next thing is you will have your patent application submitted, you'll pay all your fees, and it will go in line for examination. The patent office will then pick up your application and examine it. And that's what this next step is talking about during examination. After the examination process, which could take a couple of months or it could take a couple of years, depending on how often you have to go back and forth with the examiner, how many different office actions you submit, and we'll get to that later. Your patent will either be allowed or your application will either be allowed and able to become a patent, or it will be abandoned, in which case, that the process ends. So let's begin with preparing your application. If you look here, they have a whole list of different things that you need to do. The patent process overview, what a provisional application is, which we are not talking about today, what a utility patent application is, which is what we are filing today. So let's just say that we're going to go into the utility patent application filing process. Here are all the different things that you need to be aware of and address, which is what your patent attorney knows about and does for you, should you choose to hire a patent attorney. If not, you'll have to take a look at these different steps and make sure you're following them. The 5 key parts of a patent application are the specification. And if I click on that, it takes you down and explains to you exactly what the specification is. The next part of the application that you got to keep in mind is the figures and the drawings. You'll have a title for your invention, which is pretty simple. If you're referring to other applications, if this is the first time you're filing something, this will be irrelevant for you. But if it is not the first time you're filing something, then you need to refer to other applications. For example, if you filed a provisional application and now you're converting it to a non-provisional, this cross-reference section is important. You can identify the provisional by its serial number and title, and that will be the way by which the application will be connected to other applications. The next thing you need to have is a statement regarding if there's a federally sponsored research or any development. If you're working with the federal government and you're doing something that is funded by the government, then you need to identify that to the patent office. If you're doing any kind of biological or pharmaceutical thing, you'll have sequence listings. You don't need to worry about that right now. So if your typical application is a mechanical or an electrical application, you start off by having a title for the invention. You refer to other applications as needed. And then you come and talk a little bit about the background of the invention, which is basically identifying the problem. So this is where you would write what the problem is that you're trying to solve. Then you provide a summary of the invention, which is how you're solving that problem. This should be very brief. It should be very high level. It should not be detailed. One of the other things that you can include in this section called summary of the invention is what the advantages are for your invention. You can include that later in the application as well, but in this section, you basically provide a summary of the invention. And then the next section would be a brief description of the drawings. Now, remember, you have to have a whole set of drawings created and made, and whether those drawings are mechanical drawings or flow charts or block diagram of different electrical components interacting with one another, that depends entirely on what your invention is about. But if you look at what the brief description of the drawings identifies, is this is where you talk about the drawings. So you would basically say, figure 1A shows something, figure 2 shows, and then whatever it shows, figure 3 shows, and so forth. So that's where you list all the figures by number. Let's say you have 10 figures, so you would have figure 1, figure 2, and so on, all the way to figure 10. At that point, you've now completed this section called brief description of the drawings. The next section is the detailed description, which they have right here. This is where you go into detail describing your invention. So I'm going to spend a little bit more time discussing this because there's a couple of things that are very important. Number one, this is where you talk about your invention. So in this section, you should be referring to everything about your invention. Keep in mind that you do not want to talk about your invention in the background. This is a section where you talk about the problem. If you start to talk about your invention in the background, it could become a problem for you later in litigation if you get a patent to issue and you're going to go enforce it. Because background typically is understood to mean what is the problem you're trying to solve? And your solution is not the problem, your solution is the solution. So that's where you would maybe briefly or at a very high level describe it in the brief description, and then you would go over it in the detailed description of the invention. Now, that being said, you need to also, in this detailed description, refer to the figures to help explain your invention. So you would refer to figures, and everything within those figures can be numbered by element number. So, for example, if you have a figure that has 3 parts in it, you can label it figure 1, label one part 10, label another part 12, label another part 14. And the reason I'm using even numbers is because if I come back later after I wrote everything up and I want to add something into a figure, then it's great to have the odd numbers not used so I can come in and add the number in without having to renumber everything. Because if you can imagine, if I labeled things in sequential order, 10, 11, 12, 13, 14, and I wanted to add something in, I couldn't grab one of the unused numbers. I would have to either renumber everything or use some high number like 100 in a figure that looks and talks about 10. Now, there's nothing, illegal or wrong with that. It's just not clean in terms of the way the application appears once it's published and shown as a patent. So this is where you would spend a lot of time talking about your invention, the various parts, the various components, the various pieces, as well as identifying the various advantages and the various applications. For example, your idea may be applicable to supporting a shelf, and your idea may be applicable to supporting a table. So you could discuss your idea in both of those contexts. Once all of that is written up, then you go and write your claims. This is the most complicated part of your patent application because there are some very, very specific rules as to how claims are to be written. There are very specific rules that are used to interpret the claims, and it is the claims that you go and enforce in a litigation. So once your application turns into a patent and you want to go out and enforce your patent, it is the claims that are read by a court and interpreted in order to determine if there is infringement. So this is a section that a lot of people attempt to do on their own. It is difficult to do. It is not easy. So you might want to, at this point, consult an attorney. Now, if you write up all of the pieces that we've just discussed, for example, you write the background of the invention, you write a summary, you write the detailed description, and you write up all the figures, and then hand that over to an attorney and say, please write claims. It's quite possible that they could do that for you. Some attorneys are more than happy to do that. I do that all the time. Some attorneys don't want to do that, so they will pass on the work. Once the claims are written, you then need to have an abstract, which is, again, like a summary. I recommend most of the time that people copy their summary into the abstract. Just keep in mind that the abstract has a limit to the number of words you can have, which is 150. So if you're going to copy your summary into the abstract section, which is perfectly fine, just keep in mind that you have a 150 word limit. So if your summary is 200 words, you're going to have to somehow further narrow down your summary. Now, going back to the list of things that you have to cover, or the list of things that are here, you can see all this information now that follows, which talks specifically about the drawings and the figures, how those drawings have to be done. So not only are the claims complicated, there are a whole set of rules regarding drawings and what they have to look like and what they have to contain. So you have to either know that or submit your application, and then the Office of Initial Examination, which is not the examiner that's going to look at your case, but rather the group of people that review your application to make sure everything is there. They will send you any kind of rejection they want to give you with regards to your drawings. And then when the examiner picks it up and examines your case to see if you can get a patent granted, if they have any issues with your drawings, they will also then give you a rejection, at which point you'll have to get someone that understands the rules. Most patent attorneys do, to prepare your drawings, and or hire a professional draftsman that understands the patent office rules, and they can prepare your drawings. Roughly, you're looking at anywhere from about $30 to $130 a sheet for professional draftsmen to prepare your drawings. So if you have 3 drawings on one sheet and 1 drawing on another, that's a total of 2 sheets. You're looking to pay the draftsman approximately the fee for 2 sheets. Now, there's various different ways they charge, and that is something that's totally out of control. But you can shop around and see what's best. However, when you do prepare your drawings and file them, just be ready that there may be issues that you didn't know or you weren't aware of. For example, I will scroll down here. See here, the drawing requirements, numbers of sheets and drawings and views. So all of this information has to be something you're aware of and you know about. And from there, you can, make sure that you're not getting any rejections or any issues with your drawings. Once you have your application completed, so once again, going over it, you have a background of the invention, you have a summary of the invention, you have a description of your figures, you provide a detailed description, you provide your claims, you provide your abstract. Once all that is ready in one document, you then can submit that to the patent office. Along with that, there's some paperwork you have to submit. So there's a thing called an application data sheet that you have to submit. There's also a thing called an oath and declaration, which you have to prepare and submit. And all of that information is there. So for example, right here, you can see it says oath or declaration. This is a form that you can download from the patent office and fill it out and submit it. There's also the thing I mentioned, which is the application data sheet, which you have to submit and fill out. And the application data sheet basically has a lot of information that they ask you. in regards to the inventors' names, the addresses, the city of residence, if there's any priority claims. In other words, remember we said there was a reference to other application section. Well, that's where you identify your priority claims. And then there's some other questions about who's the applicant, who's the assignee, if you have a company that you're assigning it to, et cetera. Those are things you'd have to know. And again, these are relatively simple for someone who has done it over and over and over. However, if it's your first time doing it, expect to spend a reasonable amount of time, and probably in the order of an hour to an hour and a half, to collect the data, understand it, and fill it out. Whereas, our paralegals can fill this form out in about 20 minutes. So just be ready for that information that goes into the application data sheet and having to find it and collect it and get it in. Once you have filed your application, so you put your application together, you file the application with the application data sheet and the oath and declaration, you're now going to go through an examination process. So filing the application was this section, and now you're going to go through the examination process. And there are various different things that the examiners can do in terms of examining your application. So one way that they could reject your application is to tell you that this is something that is not subject matter eligible. This is a typical 35 USC 101 rejection. If I click on it, it will bring you to a whole section that you can look at and read, and various information that's available to you. So that's one way that the examiner can reject your application. Another way is to reject your application based on references and cited art. So the examiner goes out and searches and can come back and give you a 35 USC 102 rejection or a 35 USC 103 rejection. Those rejections are rejections that are based on references or things that the examiner has found. It would be similar to doing a patentability search. So the examiner has gone out there and searched all public databases that they have access to and found something or a combination of things that disclose what you have claimed. Now remember, it is the claims of the invention that the examiner is looking at. And that's why I said it's complicated. It's important that you get help so that we can do this information and get it all in one place for you. So the most important thing right now for you is to understand that once you get a 35 USC 102 rejection or a 35 USC 103 rejection, that there are no way that you can deal with and there are ways that you can deal with those rejections, but you have to have the expertise and the knowledge to do it. As a side note, there is one other possibility that the examiner can use to reject your claims or your application, and that is 35 USC 112. And that is more formality type of rejection. So that one is basically saying there was something wrong with your application because the claims didn't have the right support either in your specification or the claims were not written in the correct format. Most people that do their own application who are not familiar with claim writing typically will end up with multiple 35 USC 112 rejections. I see that there's some questions in the chat. We'll get to those in a second. The final thing that I want to point out to you is they do have a way that you can respond, and they have it outlined here, what the different office actions are and what the deadlines are. Again, everything will have a deadline and a timeline. And when you go to this, the application process, responding to office actions, there are various different things that you can look at and look into and read about. And finally, once you get through the process, you either get a notice of allowance or your case was rejected and there was nothing you did, so it became abandoned. Once you get a notice of allowance, your patent still has not issued yet because you must pay an issue fee. You must submit the forms correctly. You also must make sure that you have your oath and declaration on file before you pay the issue fee. Otherwise, your case will be rejected because the oath and dec is not there. Now, some people remembered to file the oath and deck at the very beginning as part of the initial filing. Sometimes they don't. It's not a requirement that you have to do it, but we recommend you do it right away. And then if you want to file a new oath and deck when you get your case allowed, you're welcome to do that. It's not an issue. You can always do that. And then once your patent issue fee is paid, or your issue fee is paid, your patent is issued, and then the patent lasts 20 years from filing. However, as with all things, you have to pay maintenance fees. So at 3.5 years, 7.5 years, and 11.5 years from the date of issuance of your patent, you have to pay maintenance fees. Each of those maintenance fees increase. Those years are listed here. So you would have to put this on your calendar, track it. And again, there are services that track maintenance fees, and your patent attorney, if they filed it for you, will track this for you. And then at that time, let you know what those fees are. And remember, as you go from 3.5 to 7.5 to 11.5 years, the fees will increase. Well, that's kind of an overview of the process. By the way, if your application is abandoned, you have basically chosen to take no action with respect to an office action that was sent to you, which we also call rejections. And as a result, you missed your deadline, your application became abandoned. Now, one note, if your application became abandoned unintentionally, somehow you made a mistake in tracking the date or the due dates, you can always revive your application. Just keep in mind that there is a hefty fee for reviving an abandoned application. And why you would do that is because you want to revive it to keep your priority date. In other words, your original filing date. That wraps it up. That kind of basically is a summary. I'm just going to show you this. This is all the different forms. You would be using the one that says filed on or after 2012. Because you're filing it on or after 2012. This is for applications that were filed before 2012, because those there was a change in the law that occurred, and so that's why this distinction between the two. So anyone who's filing something today would always use this one here. And when you click on it, it will take you to a page that has all the different forms that you can download. Remember, your application, the part that has the background, the summary, the description of the drawings, the detailed description, the claims, and the abstract. That thing is not a form. That is something that you have to write up. It only forms are here are forms that you need to file with that application. For example, the application data sheet that we mentioned, or the inventor's oath and declaration, or any other thing that you might need. The forms are here. However, the application is not a form. I'm going to now jump in and try to answer some of the questions that we have in the chat. Nicole, I know you're on. Thank you for being here with us. If you have any questions that has come in, let me know. But one of the questions I have is, okay. So one of the questions is, can I have an attorney outside of my state patent my invention? That question often comes up because people think that because they live in a particular state, that patents are filed by attorneys that are licensed in that state. That is not correct. Patents are filed by attorneys that are licensed by the US Patent and Trademark Office. So patent attorneys can work in any state across the country and represent you because everything is federal. So if you live in Alaska and your attorney is in Florida, they can still file the patent for you because they would file it with the US Patent and Trademark Office, and they are licensed by the US Patent and Trademark Office. Therefore, it is easy for them to handle that for you because it's a federal, not a state-based. There's no such thing as a state-issued patent. No state in the United States issues any patents. Only the federal government, the United States government, can issue you a patent, and that is done through an examination process conducted by the US Patent and Trademark Office. Nicole, what other questions do we have?
Amazing. Good afternoon, everyone. Thanks for joining us. We do have a couple other questions that have come in. Somebody's wondering, is it reasonable to assume that they can patent their own invention themselves if the subject matter is relatively simple?
The answer to that question is not dependent on the subject matter. I really think that whether your invention is easy to understand or complicated to understand is not important, because when you file your application, the patent office sends it to a group of examiners that are experts in your area of innovation. What is the question that should be asked is, are you familiar with the process? Are you familiar with writing claims? And have you done this before, or are you willing to spend the time to learn it? I mean, I've been doing this for almost 30 years. And during those 30 years, I'm always learning something new. I'm always adding to my knowledge base. So if you want to file your own patent application, the question you have to ask yourself is this: are you familiar enough with the process of getting and filing a patent? Not, are you familiar enough with the technology?
Great, thank you for that. We have another question that came in as well. Wondering if you need all of the inventors of your invention to be on board to patent something. So it seems like, for example, you have an invention and you're the one that wants to move forward with it, but not all of the inventors do. Is that possible? Can you do that?
Yes. Remember what we talked about? That's a great question, actually, because it happens more often than not. Remember we talked earlier about the oath and declaration that has to be filed. One of the rules of the Patent Office is this: only the inventors can be named on a patent application, and all of the inventors must be named on the patent application. Inventorship is defined by the claims. So however you write the claims, anyone that's contributed to the innovation covered by those claims has to be named as an inventor on the application. So if you leave one of them off, that's a problem for you. Your patent can be considered invalid if it issues. So you include all of those inventors and only those inventors. So you can't put your manager or your friend on because they're paying you money or giving you money to, file the patent application. So only the inventors and all of the inventors. Now, if one of the inventors decides they don't want to do it, they don't want to cooperate, there is a process by which you can file an oath and declaration as one of the inventors on the application, identifying the other inventor. So inventor 1 and 2 are okay with it. Inventor 3 doesn't want to file. So inventor 1 and 2 can sign a statement saying inventor 3 is an inventor. However, they're not being cooperative. So we're going to proceed as inventor 1 and 2 and file a statement that says I have an uncooperative inventor, and therefore I'm going to be able to complete the process of filing my application and examining it and getting the patent to issue. So yes, you can proceed with, even though you have an uncooperative inventor. The main point is only inventors are named and all of the inventors must be named.
That's great. I think really valuable information. Thanks for sharing. All right, we have one last question that we will leave you with. Let's see. Well, in your experience, have you had a client come to you that has attempted to apply for their own patent? And kind of what does that transition look like? I guess I can go ahead and assume every transition would be different, but in your experience, is it something that happens with ease, advisable, etc.?
The transition is, so that's a really good question, because the transition is simple. I mean, we just come in, we file a power of attorney, we make an appearance in the case and let the patent office know that we are here to take over. So it happens a lot. Inventors go and file their own, and then they start to see office actions and they don't know how to read it, and it's just complicated. So they come to the attorney, and the transitioning from them to us is not hard. What is difficult is having left things out of the application when they wrote it up. And now we have problems in terms of how we can change the claims or modify the claims. That being said, the transition is easy. However, sometimes not enough information or bad information was put into the application, which then can't be undone. So we then have to deal with what we are faced with. So for example, they should have said something that they forgot to say in the detailed description of the invention, or they didn't include a figure that they should have included because they didn't know what's going to happen in examination. And no one knows exactly what's going to happen, but patent attorneys have a good idea of the kinds of things that need to be in the application to support any arguments they're going to make in the future. And unfortunately, when that stuff is left out, there's very little we can do as patent attorneys.
I see. Sounds like a notorious "it depends"
It depends,
scenario.
Yes, indeed.
All right, that is great. We've actually hit our time right on the mark. Those were the last of our questions. And unless you have any closing thoughts,
I think the most important thing is to familiarize yourself with the process, and whether or not you hire a patent attorney, it's to really spend time to understand the process and how much work goes into it, so that you really are appreciative of the fact that these things take a lot of time to do, and therefore the cost to do these things are high. So the more familiar you are with the process, the more you can help your patent attorney if you decide to hire one.
great. Thank you for your time, Jubin. Sounds good.
Sure.
Let's sign off.
All right, take care.
Bye,
Thank you.
everyone.